Okay.
Hold on, I'm not the host. Oh, okay.
Yeah, you're the host
Yeah,
now, Mark.
I got it. Yeah. Let me share
Thanks,
my
Mark, for
screen.
your time for today, even though it's too late in the night.
Yeah, perfect. I'm glad to be here. And thanks for everybody for joining, right?
Yes.
As you want me to go ahead and take over now?
Yeah, sure.
Okay.
Yeah, and also guys, stay until the end. Mark is going to sweeten of this deal. Like he's going to give us a good offer for us. Stay till the end, and he will let us know the details. Thanks, everyone.
Yeah, thank you. So, as Raghu said, we're going to talk a lot about estate planning tonight and why it's so important. We'll really talk about three main things. We're going to talk a lot about, what is estate planning? And we're going to talk about all the documents that are included in a full comprehensive plan. And then we're going to talk about in the end, hey, what happens if we don't have these documents and something unexpected happens? So we're going to cover all of that tonight in about a 25-minute presentation. And then at the end, we'll answer any questions that you have. So feel free to either put them in the chat or wait to the end and ask your questions. But just, make sure if there's any questions that you have or have ever had about estate planning, yeah, tonight's the night to ask. So let's go ahead and get started. As the screen says, protecting your wealth and your health. That's exactly what we do when we think about estate planning. And that's what we conquered at Net Law. So everything that we're going to talk about tonight is based around protecting your wealth, which is your assets and everything that we've accumulated through our lives, and all of our healthcare questions as well. So let's go ahead and get started. As Raghu said, my name is Mark Sterneman. I am the Vice President of Net Law. So let's start talking about what Net Law is. Net Law is a IT company that was created out of an estate planning law office called the Hargrove Firm in Louisville, Kentucky. That's where I'm from. And what we do at the law office, of course, is we serve wealth clients. You need a lot of money to come in and speak to one of our attorneys, and we create your documents for you. And it's a great way to do everything. But in 2012, we read in a Bloomberg report that said that 60% of Americans do not have a will. That number is pretty consistent today. 60% of Americans don't have just that one single document, the will. 90% of Americans don't have a full comprehensive plan set up for themselves with all the documents that we provide. And that's scary because, well, this is the industry that we're in. Why is it that 6 out of 10 Americans choose to procrastinate on completing these documents? Because if you ask someone, hey, do you have your will? Most people will say no, but they always follow back up with, you know what? I know I need that. I know I need to do it. It's one of those things, right? So, of course, when we read these numbers, it scared us, but we also did our research on, well, why is it that 6 out of 10 Americans procrastinate? And there were two glaring reasons. One, I think we can all guess what that is. Cost, right? It's very expensive to come in and speak to one of our attorneys and get your estate planning documents created. But the second reason was even more alarming. We found out that most people nowadays don't want to go see an attorney, right? We live in a technology age, especially millennials. They're looking for online solutions. And what we did is we said, okay, well, if you don't want to come see an attorney and cost is an issue, how do we solve both of those issues? And that's how we created NetLaw, and a online DIY software where you can run through and create all of your documents in about a half hour using our Q&A software. How did we do it? We went out and we hired attorneys in all 50 states. So no matter where you live at in the US or wherever you move to later in life, you can have state-specific legal documents by creating your documents online using the NetLaw software. So why did we have to go out and hire, 50 attorneys? Well, because each state has their own rules and regulations that we have to follow. We need to make sure that we had an attorney in each state that when you go through and complete your documents online, we needed to have your state's rules and regulations in our software so that you didn't get a cookie cutter platform. You got state specific legal documents where that software was created by an attorney. In 2012, we won the James Keene Award from the American Bar Association. This award is given out each year to the company that has the best online delivery of legal documents. I'll say that again. The best online delivery of legal documents. To this day, we are still the only ones in estate planning to win that award. So something we hang our hats on every day. Who hasn't won this award? LegalZoom, Legal Shield, Rocket Lawyer, Trust and Will, all of these big companies that spend a lot of money on advertising each year, they still haven't won this award. The best online delivery of legal documents. That's from the American Bar Association about the NetLaw software. And this is everything that you get in our software. This is our full comprehensive plan. And everything that you see here, you get. One plan covers both spouses. And I'll run through these documents and explain a little bit about each document and why they're so important. Now, most people, when you think about estate planning, we think of two things, right? Our will and trust, right? Everybody says, I got to get my will and trust. But they always try to lump them together like it's one document, but it's two documents. You have your will and you have your trust. Two documents that do two totally separate things. So let's start with the will. Why is the will so important? And there's three reasons. One, we are going to name executors. Who's going to be in control when we pass away? Who's going to file our taxes? Who's going to pay our creditors? Who's going to make sure that all of our assets get to our beneficiaries? That's the role of an executor. Not only do you name a main executor, but you can name alternate executors as well. They have to be over the age of 18. We would prefer that they be someone from your own state, but it could be someone from a different state or a different country. Even overseas is fine. So that's the first reason, naming executors. The second reason, guardians. In the will, we're going to list guardians. If something happens to you and your spouse and you have children under the age of 18, who's going to raise your kids? Who's going to have custody of them? So we want to make sure that we have that listed as well, making sure that we have someone who can take care of our kids if something happens to us. And the third reason, we call it specific bequest. This is simply listing all of our assets and who those beneficiaries are. Who's going to receive our stuff when we pass away? So those are the three reasons: executors, guardians, and listing those assets and who those beneficiaries are. Three reasons of why we need to create our will. The second line item there is the children's trust. And this is also included in the will. But this is where you can decide, you know what, maybe if me and my spouse have children under the age of 18 and we both pass away, well, I know that my kid will receive his or her inheritance at age 18. But a lot of parents think that's too young, right? They're still immature. You know, do you really want to give an 18-year-old a $500,000 life insurance policy or a $250,000 401k, right? It's a lot of money to give an 18-year-old. But in the children's trust, you can spread that inheritance out over time, giving a certain percentage at a certain age so that you can spread that out over time so that as they go through life and they mature, there's a little bit of inheritance that are coming to them every so often. We call it protection from the grave, but I think it's very important to have. Third line item is our financial power of attorney. Of course, we all know what that is, right? Our POA. Having someone who can make our financial decisions for us if we can't make them ourselves. Whether we're sick, we're in the hospital, maybe we went back to India and we're staying over there for a month and something happened back here, our POA can handle all of our financial matters. The next three documents are our healthcare documents. Remember that first screen, it said protecting our wealth and our health. Well, this is the healthcare part of it. Healthcare surrogate is your medical POA. Again, who will speak for you if you can't speak for yourself when it comes to healthcare decisions? Who's going to talk to the doctors, the nurses on your behalf? Who's going to let them know your wishes? The HIPAA authorization grants people access to your private medical charts or any kind of mental health information like psychotherapy notes. Those two documents work hand in hand together, healthcare surrogate and HIPAA authorization. And the last document is your advance directive. That's your last healthcare document. In some states, it's called a living will, but this is your end of life decisions. Hey, what are your thoughts on life support? Do you want it? Do you not? What about autopsies? Do you want it? Do you not? We're keeping you in control of all the decisions that need to be made, and we're making them now before something happens and we don't have time to make them. And then we leave those hard decisions up to our spouse or our kids or family, right? We're keeping you in control as we go through life. We have a pet trust. So, if you have a pet or maybe a small farm, you can leave money behind for those animals to make sure they're well taken care of even after you pass, so that the burden doesn't fall on the person taking care of the animals now. You're taking care of that. And the last document is our revocable living trust. Remember, our trust is a probate avoidance trust. So the reason we have a revocable living trust is to avoid probate. What we're doing is we're taking our major assets, home, cars, boats, vacation homes, and we're transferring those major assets into the name of the trust. We're taking them out of our individual name and putting them into the name of the trust, so the trust owns the asset. The trust is the only document here that will allow your beneficiaries to avoid probate and receive those properties right away. Very, very important. The big thing is everything in a will still goes through probate, but anything that you've transferred into your revocable living trust avoids probate and is passed right away to your beneficiaries. All of these documents are included, and we even have 1 free year of maintenance subscription. That means for the first year, you get full access to your account. You can create your documents. You can edit your documents. We have a My Files section. It's an online security vault where you can store all of your important data in one safe and secure spot. Everything's included for 1 year. And if you want to continue after the first year, it's simply $8 a month, or you can cancel out of that at any time. All of your documents are still in your vault. You can access your vault at any time. The only thing that you would lose is the ability to edit your documents at a later time. But you can always call us. We can reopen your account for $250. And the last line item here, we always have a 7-day money-back guarantee. For any reason, if you're unhappy, as long as you haven't downloaded your documents, we'll give you your money back. All of this at our price is $600. I know Raghu mentioned a special price. And, if you get with Raghu during this webinar at the end or later on, he will have the ability to offer this for $300. And again, $300, one plan, both spouses. So we're giving him a 50% discount on this. It's an unbelievable price at $600. It's even just more amazing at $300. Just for comparison, this plan in our law office starts at $3,000. So 1/5 of the cost with our regular $600 cost, because we've already paid the attorneys to do all the work. So, of course, once this webinar is over, get with Raghu, and he can make sure that you get a voucher code that will allow you to receive this for $300. I talked about all of these documents being revocable. That means you can go in and change them at any time. So I'm not going to go through this full slide, but as you can tell, these are reasons why you would ever need to come in and edit your documents. This is why I always like, and I tell people, it's a great idea to leave your account open, because if you have a child or you adopt a child or you have a new grandchild, right? We want to add these kids in so that we can leave them something behind. How about relocation to a new state? If you're in Texas now and you create your documents and everything's great, but you get a new job and you got to move to California. Do you have to start the whole process over, pay the fee again? No. All you have to do is log back into your account, change your address, the system will update to California documents then. You just run through the documents one more time, create your documents, print them out, get them witnessed and notarized, and you're done. The days of going back and forth every time there's a change needed to the attorney's office, that's over. Just to come in and do one change in our law office is around $300. So you can see why keeping that $8 a month is so valuable. So we've talked about what NetLaw is and why we were created. And we've just went through all of the documents and why they're so important to have. But my last 4 slides that I'm going to show tonight are going to concentrate on what happens if we don't have these documents. And everything that we've already talked about, I'm going to come from the other side now. And what happens if we don't have these documents? Remember in the will, I said that we got to list our assets and who those beneficiaries are. But what happens if we don't create a will? The government interferes. It's called intestate. And that's the only legal term I'll use tonight. But intestate simply means that you passed away and didn't have a will. So the government says, okay, you didn't list how you wanted your assets distributed, so we're going to decide for you. And every state has intestate laws. I'm in Kentucky, that's my home state. So intestate law, if I passed away and didn't have a will, 50% of my individually owned assets would go to my spouse. The other 50% would be split between my kids. Now, that's not how I want my assets distributed. Of course, I want, like most people, I want everything to go to my spouse and then to my kids. But that's not how it would work if I didn't have a will. So making sure that we create our will and make sure that we know where our assets are going, who's receiving them. And this will stop a lot of family fighting as well, because we've heard all the time where kids are fighting over everything mom and dad had, and now the kids don't talk to each other, right? This solves all of that. There's not going to be any fighting because you listed everything and who's going to receive it. So this is always the first thing that I talk to with my clients when they come in and see me, unless I know they have kids under the age of 18. Then this is the first thing that I talk about. In the will, remember, we're going to list guardians. Who's going to have control and custody of our kids if something happens to mom and dad? Well, without a will, we didn't list guardians. A judge will come in and decide who has custody and control of their inheritance. A judge. Now, there's 55 people on this webinar. I can almost guarantee that all 55 of us agree that we are a better judge of who we want to raise our kids than that judge, right? So knowing who we want to raise our kids, who's the best fit for this, and we want to leave it out of the government's hands. And again, it's going to stop all the family fighting, because can you imagine if mom and dad pass away and there's kids under the age of 18? Mom's side's going to come fighting for the kids. Dad's side's going to come fighting for the kids, and it's going to turn into a mess, right? Again, we're listing everything and what's going to happen in case we need to have that decision made. We're making it now for later. We talked about the revocable living trust and why it's so important, having the ability to keep our beneficiaries out of probate court. Well, if you've ever known anyone who's went through probate, they will tell you that it is very expensive. You have to hire an attorney. You have to go to court, or the lawyer will go to court for you. On average, probate usually costs around $6,000 to $8,000, and that's if no one can test anything. But by creating that revocable living trust, and again, transferring your major assets to it, home, cars, boats, vacation homes, that will keep those beneficiaries out of probate court for those major items, and they'll be able to receive those assets right away. Remember, with probate, everything is frozen by the government until the probate process is over, which could last anywhere from 6 months to a year. Having the ability to get our major assets to our beneficiaries right away is so important to them. so that they may need to sell the car or the house to pay off the bills. Or maybe the house is just going to them. They have a house, they don't need it. They can go ahead and sell it and keep the money that's been recouped off the property. But just keeping our beneficiaries out of probate will save them so much frustration. And what happens if we don't have those medical documents? You know, the medical power of attorney, remember, having someone to speak for us if we can't speak for ourselves. If we have any religious beliefs when it comes to medicine or doctor's care, or, you know, if there's a certain procedure or something that we want or we don't want, who's going to speak for us if we can't speak for ourselves? And that advance directive, end of life decisions, right? So important. Do you want life support? Do you not want life support, right? Keeping us in control with everything up to the day that we pass, so that everything happens to the way our wishes were directed. That's why we do this. That's why we create these documents, so that everything that we want to happen, happens. So that's really Net Law 101. I hope you found that very educational. And let me take the time to turn it back over to Raghu. And if there's any questions that anybody has, again, he's given a 50% discount for those. So get with him after this webinar or at the end of the webinar so that he can grab your information. And Raghu, let me turn it back over to you, and we'll answer any questions that anyone has.
Thanks, Mark. This was a good session and good overview. There are some questions in the chat. Can you go over them?
Let me click that. Okay, first one from Basha. What is the difference between executors and guardians? Guardians are only responsible for the children. Executors will handle pretty much everything. Your executors will pay all the creditors. They'll pay your taxes at the end of the year. They will make sure that everything that has to do with the estate is taken care of. They will actually get the kids to the guardians, but the guardians are only responsible for what has to do with the children. They will raise the children and take care of the children's inheritance. So that's the difference. Does the guardian need to be in the States, or can they be from foreign country too? We would always prefer that the guardians be from the US, because if anything happens, someone needs to come grab those kids before they go to foster care or into the state system. So we want to make sure that someone can get to the kids, like if mom and dad pass away in a car wreck, right? Someone can grab those kids so that, you know, the family courts don't get involved and decide who's going to have custody of the kids until someone can get over here to claim them. So we would always prefer that a guardian be from here, but it can always be from someone overseas as well. So you can do that. It's just, you know, maybe you need to name both so that someone can act right away on that. But good question. Guardian for children and both husband and wife pass away, and executors who take decisions on your behalf and distribute assets or take decisions on your behalf. I will let Mark jump in and add more information. Okay, I think we've already pretty much answered that one. What is the privacy on personal information? Like, who can see the information we enter? So, you know, you can enter it. If you want to give anybody your password and username, you can do that, maybe to family members. But what I would suggest is just maybe giving your executor and your guardians a copy of your will and trust, just in case something does happen unexpectedly. They have your documents and they're ready to go with whatever needs to be done. As far as privacy information, you know, in the software, we only ask for your name and date of birth. We don't ask for your social security number at any time in our software. So I hope that answered your question.
I think we want to know how secure are the documents.
can one kid who is above 18 be a guardian for the second kid who is below 18 if both spouses are? Yes, but remember, if a kid is 18, do you really want them raising a 10-year-old, 11-year-old, right? Is that 18-year-old mature enough to be mom and dad? What happens if the kid's going to college at age 18? They need to quit college, get a job. I think there's probably a better solution for that. But legally, yes, that 18-year-old could be a guardian for the child. Will there be consultation available while I fill out the forms? Yes, we have a chat bar that's up in your upper right-hand corner of your NetLaw account. You can click that, speak to one of us, and they can actually turn that chat into a video call so we can see your documents and help you complete those documents. Oh, thank you, Srini. You're already answering these. I love it. Are all the properties abroad covered in the will? Yeah, sir. You can list all of your properties in the will. Remember, I always call the will the checklist, right, for your executor. So you want to list all of your assets so the executor doesn't miss any, and all assets get distributed to your beneficiaries in a timely manner. Will the beneficiaries of the revocable living trust receive a step up on basis of asset value when assets are inherited by them? No, they'll receive they'll receive that asset. So if we're talking about a house, the house would be sold and the profit off of the house would be distributed to the beneficiaries. If there's any kind of jewelry or anything like that jewelry would be passed to the beneficiaries and they would receive that value of the asset. Balajan, let me know if I didn't answer that exactly how you wanted it, or if there's anything that I didn't cover on that.
I was just curious to know, like, if the house, like, say the parents bought it for, like, say 500,000, and when they actually beneficiaries inherit, might be the house value is $1 million.
Yeah.
Then when they sell the house, will the beneficiaries have to kind of pay taxes for that remaining 500, or the basis for them?
Yeah, they'll pay the property tax of whatever the house is valued at. So if it's $1 million, that's what they're going to pay on.
Got it.
Yep.
Thank you.
Mm-hmm. We've already answered that one. Are there any limitations on number of changes to the docs, will, trust that can be done? No, as long as you have that open active account and you're paying the $8 a month, it's unlimited access to your account. Can we add out of country persons or guardians? Yes, you can. Okay, we've already answered that. Okay, I went through all the chats and answered them all, it looks like. Oh, one more just popped in. I guess the will help the assets from US only. What about the assets from overseas? Sure, you can list your assets overseas into your will. So that makes sure that the executors know everything that you own so that they can act upon that. Now, remember, any assets over in India, we all know how easy that is, right? They all get passed to the spouse and then to the kids. So what a lot of people do is they create their will and trust here for their US properties, then they go ahead and create their will over in India as well, and have it listed over there. But if you only want to do one, you absolutely can list all of your India assets into your US will. But remember, that's only a checklist, right? We still have to follow India law for the properties that's residing in the country of India. Yes, guardians, executors, anything, as long as you have an open account, you can change anything in your documents. Let's see, what level of info do we need to get from executors and guardians? Yeah, so we just need to know their name and date of birth and where they live, what state or country.
So I have a question, sir.
Yeah, go ahead.
So let's assume I bought a house at 300K, and when I die, the house cost is 600K, and the survivor sells the house. Will he pay the tax on 300,000 as a capital gain if he sells it, or is there a way we can save on tax after they sell it once I die?
Yeah, so that's a really good question. Yeah, he'll pay the taxes on it as a capital gain. But remember, what I would tell him to do is, of course, talk with his CPA about any kind of tax. This is just a probate avoidance trust. This trust will not help with taxes at all, none. So what I would highly suggest is if we're getting into where houses have doubled or tripled, definitely talk to a CPA about tax advantages because they would probably want to look at more than just that, because the more cash value that you have, the more you could probably save in your taxes doing some kind of, strategy work. But that would be through a CPA, not us.
I was reading somewhere that, when we create a will or a probate or some kind of a living trust, we can do that. Do you offer that facility?
Yes. Say the first part of that again. You kind of cut out on me.
So I was reading somewhere that, if you have a living trust or some kind of probate in which you don't, you're not giving the property directly to the survivor, but you are creating a trust or some kind in which if they sell it, they don't get taxed on the upside. They don't get.
You can do that. You can get like irrevocable trust, asset protection trust, stuff like that. That's what we don't offer here. We've kept this as easy as possible. But if you're looking for that, it wouldn't come through us, but you could get with Raghu and we could have a side conversation and I could get you contacted to one of our attorneys in your state and they can help you.
Hi, Mark. Good evening.
Hello, sir.
Hi, Mark. Can same person as an executor and the guardian?
Oh, they can be. Yeah, they can be the same person.
Okay, so let's say my cousins are here in US. If something happened and if executors or guardians are my cousins in US, so actually, but we have to hand over kids to India. So do we have to mention that clearly what needs to be done, and we have to mention guardians in India?
Yeah, you would. Yeah. So, remember, because in the software, you can name main guardians and then alternates as well. As long as like your cousin who's here is listed, they can grab the kids if anything happens. And then you would just have a conversation with him saying, hey, if anything happens, grab the kids, but then get them back to mom and dad in India or whoever, right? So yeah, that would be just a conversation that you would have with them, but you'd want to list each of the guardians.
In the will, do we have to mention executors also for sure, or only?
You want to name an executor because that's the person who's going to get the kids to the guardians.
Sure. So, how about this trust process, Mark? Actually, it will take. Do we have to go to county to register everything? A trust or?
So right now you have a deed to your house, and what you would do is you would take that deed and a copy of our certificate of trust, and you can go to the title company or you can go to the county clerk's office and just tell them that you want to put your house in the name of the trust, and they will create a new deed for you in the name of the trust, not your individual name. That's called funding the trust, and that's putting the property in the ownership of the trust. But key thing to remember is you are always the trustee of your account for as long as you're allowed. So you don't lose any authority. You can sell that property at any time.
So do we have to pay anything in the county for the
Well,
trust?
you would have to pay for the deed. I did mine about 7-8 months ago when I bought my house, and it cost $79. So it's not very expensive.
So sure. So even though both spouses' names listed in the deed, but still we have to register that deed into the
Yeah, because
trust.
it has to be,
trust.
yeah, it has to be in the name of the trust. Because remember, just creating the trust alone does nothing. You have to take those assets and transfer it into the name of the trust so the trust owns it. That's what avoids probate.
Sure, no problem. Thank you, Mark.
Yeah.
And if we have, let's say, any company or employees or something, does a will and trust anything can affect in company any way?
Like, can you put your company into the trust?
No, not like that. Company is different and will and trust is different. But if is there any issues or loopholes having like that with the will and trust?
No, none that I can think of.
Okay, sure.
I think his question is like if he has company, if somebody sues the company, right? Will it impact the will and trust assets in the trust? That's
Right.
what your question, Giri?
Oh, maybe. Yeah, maybe.
Yeah.
Something like that.
In that
kind of.
case, yeah, in that case, then yeah, you would want to talk to an attorney about an asset protection trust that would protect you from lawsuits, slip and falls, stuff like that.
Okay, excellent.
Yeah.
Thank you so much, Mark, for your information.
Sure.
Thank you. Have a good day.
Any other questions that I can help with?
There are a couple of other questions, Mark. Can you please check
Oh,
those?
in the chat? Okay, let me go look.
Yes.
Yeah, we already talked about capital gains. Definitely talk to your CPA about that because there's ways that they can deal with that.
Yeah, if they can inherit the property at the same time as such, they can sell it and they don't have to pay the taxes.
Right. No,
Or
exactly.
they can do 1030.
Yeah, that's what we're talking
or-
about. Yeah, it's not when you receive the property, it's when you sell it.
That's right.
Yeah.
And also, like if you inherited the property at the same time, for example, tomorrow, and you can sell tomorrow, you don't have to pay taxes because it's not appreciated.
Yeah.
That is one thing. And if your kids can occupy the property as a primary residence, they don't have to pay taxes. Or even if they rent it, they don't have to pay taxes. Or even they can do 1031 exchange. They can sell the current property and buy another property at some other place, their residence or something. At other place, they don't have to pay taxes on those.
Yeah. Always talk to your CPA about that. Any other questions? These are really good questions.
Hey, Mark, this is Jay. I have a question. So if there are some rental properties that are under an LLC name, can they be part of the same trust as the primary home?
Sure. You can actually transfer your LLC or corporation into the name of the trust. So that way, anything that's under the LLC, it's kind of like an umbrella effect, right? If you transfer the LLC, everything that's under the LLC is now in the ownership of the trust.
Oh, I think his question was also like, do we need to have separate trust for separate homes or like,
Yes.
No, you can just have one trust and transfer everything into it.
into one trust? Okay.
Right.
Thank you.
Thank you, Mark.
Hi, Mark. One question, please. So let's say in guardians in US, once kids hand over to guardians, even if somebody don't have visa to come to USA, so even guardians can take care and they can pass on to the India, right?
Correct.
Okay.
Yeah, that's why it's so important to have someone listed here in the US. Even if you really want them to end up back with, like, say, your parents or your brothers and sisters back in India, it's so important to have someone at least listed here so they can grab the kids and do what you do what you wish for the kids. Hey, let's get them back over there.
The same state is recommendable, maybe right?
Same state
Guardians
is
and
always recommendable. Yes, because it's
Okay.
easy, right? They can just drive there and get them.
got you. Excellent. Thank you, Mark, for all this service. I think it helps really a lot. Thanks
Sure,
so much.
thank you.
Yeah,
Thank
and
you.
Raghu also. Thank you.
Mark, a quick question.
Yeah.
So if there are, can we have multiple guardians? So the first guardian is not in a capacity to, perform as, or is not in a position to, take care. So is there another level that we can appoint
There is,
guardians?
yeah. So you name your main guardians or your main executors. But then you always name alternates as well. So if the first people you name aren't able to fulfill that row, then it falls to your successors.
Thanks.
There is one more question, Mark, from Naveen. Two questions. What happens after the US guardian took the kids? Are they liable for disclosing any kids' information if they send the kids to India or to other guardians?
Yeah, so everything's filed with the family court system. The family court will know what happens to the kids, who receives them, and all of that. And yeah, if they're moving back to India, there's paperwork that'll need to be done, but that'll be through family court. And then is 300 premium one-time payment or each year? No, it's the 300 will be a one-time fee. And then if you want to continue after the first year, it's just $8 a month.
Just want to clarify on this $8 per month. For first 1 year, it's a free. You don't have to pay anything other than $300.
Right.
And you can stop the monthly payments. And for example, after 5 years, you can bought another property asset. You want to include that into trust. You can just pay $250 and I get 1 more year. So you can do all those changes in that
Right.
year, all new assets, new findings, right?
That's right.
Am I correct, Mark? Just one.
Yeah, so it's
Correct?
you pay the so if you cancel out of it and you pay the $250 reinstatement fee, yeah, that opens your account up. But in your situation, yeah, it's good. You want to open that up and add that new property into your will and trust. But one thing to remember is, at closing, have your title company create the deed in the name of the trust. Don't let them do it in your individual name, because then you'd have to go back to the county clerk's office and redo everything. So have it anytime you buy a new property after you create your trust, have the title company create the deed in the name of the trust. It'll save you time and money. And when we reopen your account, you have 1 month. 1 month to make all the changes, and then you either pay the $8 going forward, or you cancel out of it again. So it's not 1 year; it's 1 month.
Thank you, Mark. Good evening, Mark. Actually, how many members maximum can be as a guardians and executors in the will and trust?
Yeah, you can name as many as you want, but you want to be frugal about that too. You don't, maybe 3 or 4 is plenty. Because remember, you can always log back into your system and take people out and add people back in.
Okay, and always when we do change, we have to notarize and give copy to the executor or guardians.
Yeah, you're correct.
Okay, sure. Excellent.
Does
Yeah,
anyone
can you
have
hear
any
me?
questions? Yes.
Yeah, we can hear you. Did somebody have a question?
Hello, Mark. Can you hear me? I have a question on the subscription.
Yeah.
So, so the $8 subscription fee means you can make changes to the trust anytime, or is that?
Yeah, as long as you're paying the $8 a month, you can make any changes at any time.
Okay, perfect. Thank you.
Hi, Mark. One quick question, like, so when we create a trust, do we have to start filing taxes if the trust is getting any income, like it generates any income? Do we have to file a tax for the trust every
No,
year?
you won't, you'll file taxes like you always do with your individual name. Really, the trust, unless it has because it really doesn't matter until you pass away. And then what's valued in that is what's valued in it. So it really won't be gaining anything because you're still alive. Does that make sense?
Yes, yes. Mhm.
Mark, this is Mohan. I have a question.
Okay.
So the once we create this trust document on NetLaw, it is a living document on your site. We'll be paying subscription. For example, after 5 years, we don't want to be with NetLaw. Can we use the same document with another similar company?
Yeah. Well, you wouldn't use it for a similar company, but you could use you have your hard copy of your documents. So you could use those if something happened. But yeah, another company won't take our documents and then fix them for you. You'd have to start all over with them.
Got it. Thank you. One more question, Mark. So I understand we need to transfer the properties, for example, our home, the one we are living into the trust. But later in the point, selling, would that be a challenge because it's part of the trust?
No, no. I just went through mine when I moved from one house to another. The old house was in my trust and I sold it because, even though I had a mortgage still on it, the mortgage was still in my name. The only thing that transferred out of my name was the deed. So I sold it without any problems.
Thank you.
Mark.
Hey, Mark.
Yes.
One question. We now that we are including in our will the properties that are in a foreign country, and we are making changes, meaning selling of few properties. So how do we make changes? Like it's like how often we can make changes?
Yeah, as long as you have that open and active account, you can make changes as many times as you want.
Okay. And after that, it's only if we are not taking the subscription, monthly subscription, so it's only $50, right?
Yeah, it would be $250 to reopen your account so you can make that change. But if you never make any changes ever, you create your documents and you never make a change again, the only fee you would pay is $300 to get the program.
Got it. Thank you.
Hey, Mark. So regarding the timing, do we need to get this title, at the county office, or the deed to the trust first, and then work with NetLaw, or how does that work?
You'd work with NetLaw first so you can create all the documents.
Okay.
Because you would need to create your certificate of trust. They need to see that when you go to get your deed transfer.
And is there a timing, is there a limitation, I need to, change
No, you
this,
can do it at
home?
any time. Yeah, you create your documents. You can do the deed transfer at any time. Of course, I'm going to tell you, you need to do it right away because you never know what's going to happen, right? So,
that's
but
right.
yeah, I mean, do you have to do it the next day? No, you don't have to, right? But sooner the better.
Sooner the better. Okay, thank you.
If you guys don't have any more questions, we can wrap for tonight.
One last question, if you guys don't mind. So for the
Sure, go ahead.
For the transfer of the deed from personal to the trust, the county would be charging fee for that, correct, Mark?
Yeah. I just did mine 7-8 months ago, and it was a $79 fee.
No, I was kind of thinking that it would be based on the value, but apparently not.
No, they just charged me for whatever the deed cost, and that was it. Yeah, I thought it was going to be about 100, 150, so I was pleasantly surprised. And that doesn't happen too often at the county clerk's office.
So the membership, the $300 one-time fee starts as soon as we subscribe. Like, for example, like I may not be right away starting. I may have to do obviously line up certain things in India before I start, maybe 3 months down the road. But I want to take the advantage of the $300 membership.
Yeah. So what happens, you'll receive an email from Raghu, and in that email, you'll activate your code. The day you activate your code is day one.
Hi, Mark. I have one last question, actually.
Okay.
I got everything what I was looking. Like every time I change my will, do I need to update my trust also? Means every time once I change my will, like I change any details in the will, like maybe the executor or maybe the property details, do I need to update my trust also
Yeah,
every time?
If you're just doing like an executor, no. But if you're adding a property or a car or something like that, yeah, because it's going to transfer. Your property is going to be in both your will and your trust. So yes, you would have to.
And after that, I need to get legalized with the county office, right? After that, once I get the trust also updated, or one time only I have to pay the $70 or $80 fee, whatever you are mentioning in the.
Well, it was
like
it was
before.
$79 for me. I don't know how much it's going to be for you.
I'm just giving that amount every time I update my trust also I need to pay to the county.
No, you're only creating the trust and
Is that one-time
transferring that
fee?
asset in. So if you're just changing something, no, you don't have to keep doing that at the state. Only if you're adding like a new property into it. That's it.
Okay, thank you, Mark. I got
Mhm.
my answer.
Yeah, thank you.
Yeah.
Raghu, I'll turn it back to you.
Sorry, someone has a question.
Raghu and Mark, thank you so much for this session. Very informative, very useful.
Great, thank you.
Hey, Raghu,
You're
I was
welcome.
about to ask. I was about to ask one last question about pets. So I know, Mark, you mentioned about pets can also be included in the will, right? So
Yes.
can it be separate guardians for the pets and different for kids?
Yeah, you actually name someone who is going to have custody of your pets if you pass away.
Okay, perfect. Thank you.
Yep.
And also, Mark, just to clarify, whenever we have like reinstate the account, right? For example, we didn't do after 12 months, so we can pay 12 into 8, $96 and do that, right? Instead of 250.
Right, yeah. 250
That's
is
right.
the most you'll ever pay.
Yeah, just want to clarify everybody. You can do like calculate $8 per month, or max is even after you do it after 10 years or something, you're only paying 250 to reinstate.
Sorry, Raghu, I missed that part. So what is that? I thought the subscription is monthly, right? So
Yeah, so
No,
it's $8 a month after the
Okay.
first year. That'll keep your account open and active. But
Okay.
if you want to cancel out of that and then come back at a later time, the reinstatement fee is anywhere from $8 to $250. And what we do is we charge $8 a month for however many months you were closed.
okay.
So if it was
Okay, got
10, so if it was 10 months and then you needed to come back, well, you're only going to pay $80. But if it was
Okay, got
10 years, it's going to be 250. 250 is the maximum.
Okay, that's good to know. Thanks.
Guys, like here is my contact details, my cell number, and also my email ID. Or you can have this meeting invite, HubSpot meeting invite. If you have any questions, further questions, you can reach out to me via our cell phone number or email. Okay, I sent the contact details via chat also. Can we get the recording, please? Yeah, sure. I will post the recording. Sure.
Thank you, Raghu and Mark. It's really appreciated. Thank you for all your help.
Yeah, thank you.
Sure, you're welcome.
So much, guys.
Thanks, Raghu, Mark.
Thanks, Mark, for your spending your night time for this.
Yeah, absolutely.
Thanks, Mark and Raghu.
Sorry, someone has going to question. Do anyone has any more questions? Okay, then we are good. Thanks, Matt. Thanks
Yep.
for your time. Thanks, Jenny, for answering all the questions, and thanks everyone. Okay, please reach out to me if you have any questions. Okay, and this is very, very important, guys, and please make sure to get this done to protect your families. Okay, thanks everyone. Bye-bye. Good night, everyone.